Also, Lordship, there because of co-accused has been granted bail.
Why interlocutory application is there
Lordship, may
in 4?
For Lordship, some interview application file. A medical document has been. Four. Some, Lordship, on medical ground, there are they filed some medical documents.
No, which item we are taking up?
Four.
4.
4, 6, 7, and 8. Yes, sir.
Issues are similar issues.
Lordship, in my opinion, all are similar issues. Because in all cases, co-accused has been granted bail by your Lordship. And delay in trial, another ground. And
Supplementary causes.
long inclination in jail. However, the counsel is not there. In item 4, counsel is not here. So due to
Item 4 will take up later on. You make submission as regards 6, 7, and 8.
Lordship. Lordship, yesterday I placed before Lordship the facts of each of case. Now, Lordship, regarding Lordship, in my opinion, this matter is relating to NDPS case. Narcotic is not a common offense. Lordship. It is a offense. Some peculiar object of the act is there. Lordship. That is to be taken into consideration while dealing with the such type of cases. Lordship. Because in case of murder, Lordship, it affects only 1 or 2 families. But in case of involvement of drug, Lordship, the entire society is affected. Not 1 or 2 persons. Lordship. And Lordship, in all the cases, charges have been framed. And the trial court has found sufficient materials against the accused person to proceed with that. What at the end of the trial, what will happen? That is upon the what type of evidence has been led by the prosecution. Whether because in NDPS case, all sections are to be complied with meticulously. If there is any deficiency, then they are entitled to bail. Recently, in Supreme Court, in case of 42 and 52, that 60 compliance is necessary. When if it is not complied with, then they are entitled to the benefit of doubt and they are entitled to acquittal. That is altogether different. But Lordship, when the trial court found that there is a prima facie case against the accused person to proceed with the trial, and Lordship, another Lordship has also considered that delay in trial may be a ground for granting bail, even though it is a section 37 will not be applicable. In my humble submission, Lordship.
No, not delay in trial, prolong incarceration.
That, Lordship, that is the same thing, Lordship.
No, suppose the accused is on bail and then there is a delay in trial.
No, Lordship, yes.
Then
That-
question is different.
When the accused in jail,
When accused in jail, then there is delay in trial. Then only they will get benefit.
Lordship, in my humble submission, that cannot be a ground for enlarging a bail in such type of case where heinous crime is involved. And Lordship, yesterday I placed one judgment, that is Kalyan Chandra Sarkar. Lordship, basically the argument was placed before a Lordship that Article 21 is violated. Lordship, in all the cases, the accused were not arrested for any other offense or without following due process of law. Due process of law was followed, and all the offenses under the NTPX are non-bailable offenses. Even it is a small quantity, then even then the offense is non-bailable. So when a accused has been arrested in case of non-bailable offense, then Lordship, Article 21 will not come into play. And in one of judgment, Lordship, yesterday I placed that even there is a delay in trial when the accused is in jail, that cannot be a ground for releasing them on bail. In Kalyan Chandra Sarkar, yesterday Lordship, I placing the copy today.
Can they Yes, the judgment blocking. Itu sari naman. Yes,
And Lordship knows that the NDPS Act is a organized crime. After Tufan Singh, Lordship, the situation of law has been changed. That the statement recorded under section 67 that cannot be relied as an evidence during the trial. Earlier, the situation was different, Lordship, but after Tufan Singh, Lordship, I want to place one judgment with regard to object of the act. It is 99 SCC page 429. Lordship, paragraph 6 and 7.
1999 4 SCC.
99 9 SCC page 429. Union of India versus Ram Samuj. Actually, I am relying on paragraph 6 and 7. Lords. May I read, Lords?
Yes.
It is to be borne in mind that the aforesaid legislation mandates is required to be adhered to and followed. It should be borne in mind that in a murder case, accused commits murder of 1 or 2 persons, while those persons who are dealing in narcotic drugs are instrument in causing death or in inflicting death blow to number of innocent young victims who are vulnerable. Its cause and deleterious effects and deadly impact on the society. They are a hazard to society, even if they are released temporarily. In all probability, they would continue their nefarious activities of trafficking and or dealing in intoxicating clandestinely. Regions may be large, region may be large stake and illegal profits involved. This code dealing with the contention with regard to punishment under NDPS Act succinctly observe that the adverse effect of such activity in Durand Dealer versus Chief Secretary Union of Territory versus Goa as under with deep concern, we may point out that the organized activity of the underworld and clandestine smuggling of narcotic drug and subsidiary substance into this country and illegal trafficking in the drug and substances level lead to drug addiction among the sizable section of public, particularly the adolescents and students of both sexes, and means has assumed serious and alarming proportion in the recent years. Therefore, in order to effectually control and eradicate this proliferating and booming devastating means causing deleterious effect and deadly impact on the society as a whole, the Parliament in the wisdom has made effective provisions by introducing this Act of 81 of 1985, specifying mandatory imprisonment and fine. To check the means of dangerous drug floating the market, the Parliament has provided that the persons accused of offence under NDPS Act should not be released on bail during the trial unless mandatory conditions provided in Section 37, namely, there are reasonable ground of believing that the accused is not guilty of such offence and that it is not likely to commit while on bail, are satisfied. The High Court has not given any justifiable reason. That's the observation in this case. So this is the purpose of the Act, Lordship. So we cannot treat the other offences with the narcotic offences at the par. And Lordship, delay in trial of long incarceration, Lordship, there is the period for which accused is be jail is not defined anywhere, Lordship. Yes, there are many judgments of Honorable Supreme Court. Lordship, I'll say that the orders which cannot be precedent. However, in case of Muhammad Muslim, law has been let down as stated by Honorable Supreme Court Satyendra until earlier Lordship has earlier submitted that in case of NDPS, section 436 capital was not applicable. From the judgment pronounced by the Supreme Court from the Satyendra Prasad until this section was made applicable in case of NDPS also, which also Lordship I want to place. The cost of the repetition, I want to place section 436A. Lordship is the maximum period of which an under trial can be detained, where a person has during the period of investigation, inquiry or trial under this code of an offense under any law, not being an offense for which the punishment of death has been specified as one of the punishment under the law, undergo detention for a period exceeding up to 1/2 of the maximum period of imprisonment specified for that offense under that law, shall be released by the court on his personal bond with or without surety. So Lordship, here the section mandates that maximum sentence to be calculated for releasing a person on bail if he is under trial, Lordship. And in NDPS, Lordship, maximum punishment is 20 years, Lordship. If he calculates that, then it comes to 10 years, Lordship.
So before 10 years, the person cannot be released.
Yes, in my humble submission, he cannot be released,
Assuming I am giving you a situation,
Lordship.
suppose charge sheet has been laid
Lordship,
under 21C against an accused person.
Lordship.
And for 10 years, for 9 years, not a single witness has been examined by. So whether courts are handicapped.
No, Lordship, then section 37 will come into play. And if we
So
calculate
37 comes.
before that,
Courts
Lordship,
have to wait for 10 years.
yes, Lordship, in my humble submission. Because law mandates for that, Lordship.
Okay.
And Lordship, yesterday I placed on judgment that Kalyan Chandra Sarkar versus Rajesh Ranjan, where in paragraph 9, Supreme Court says that if a offense is non-valuable, then how much during the trial he is to be remaining in jail. And recently in Gurvinder Singh,
No, what section 9 says?
Lordship,
What paragraph 9 says?
Lordship, I am placing. Yesterday I have given the copy, Lordship. No, it was not. It was the division benefit. Division benefit.
Para 18.
I'm sorry, Lordship, I'm placing it.
Yesterday you have mentioned
Yes, I've given one judgment.
para 18.
I'm placing it. Paragraph 18 Lordship. It is retail law that personal liberty
No, you
cannot.
have read yesterday.
Yes, so in my humble submission, that was the law laid down by the Honorable Supreme Court, Lordship. Such detention cannot be questioned as being violative of Article 21, since the same is authorized by law. Here, Lordship, they have been arrested for committing offence under NDPS Act. And in all the cases, Lordship, charge has been framed on being found the sufficient material against all the accused. Lordship. And in all the cases, subject to correction, Lordship, they are in jail for 2 years, maximum 3 years, Lordship. And in one case, Lordship,
So your submission is till they complete half of the prescribed punishment, they cannot be released.
yeah, they cannot be released.
Okay.
And even if Lordship finds that as contemplated in section 37, then of course, Lordship, if Lordship come to a conclusion that even then before that they are entitled to bail, Lordship. But satisfaction of the court is mandatory, Lordship. Then Lordship, delay in trial, probably all this judgment will cover. And Lordship, Ravi Prakash, then all other orders, Ravi Prakash, then Muhammad Muslim, and all the judgments submitted by my learned friends from the petitioner side, all were passed by the two judges bench of the Honorable Supreme Court. Even only uh, Muhammad Muslim has laid down some law, but other cases, Lordship, even the facts were not considered. On particular facts, circumstances of the case, they were released. In some cases, when they completed 1 year, then they were allowed to go on bail. In one case, 1.5 year, but nothing has been let down.
No, in no case, in 1 year,
Lordship, 1.5 year probably.
only minimum 1.5 years in all cases.
Like that, Lordship. In Ravi Prakash, he was in jail for 3.5 years.
Yes,
In
the minimum period which Supreme Court has given the benefit of
is-
prolonged incarceration is 1.5 years.
Lordship, in my also, they cannot become a precedent, Lordship. Except Muhammad Muslim. In Muhammad Muslim, Lordship, he was in jail for 7.5 years. Out of 62 witnesses, only 31 were examined. And in that case also, Lordship, 436 was
Whether there is a long delay or not, it depends on facts of each case.
each case, Lordship. In Allahabad, Lordship, yesterday I submitted one judgment of Allahabad High Bar Association, Allahabad High Court, Lordship, the judgment. Allahabad High Court Bar Association, Lordship. In paragraph 28, 31, 32, and 37C, all these aspects were considered by the Honorable Supreme Court by dealing with the case where stay can be granted or can be granted beyond whether stay will be automatically vacated after 6 months. During considering that aspect of the matter, Lordship, the full bench of the Honorable Constitutional Bench of the Supreme Court come to a conclusion. All Lordship, delay in trial, then burden on the trial courts, whether Constitutional Court can direct the trial court to complete a trial within a specified period. All points were considered in details. Lordship. And in paragraph 37C, the Constitutional Court in ordinary courts should refrain from fixing time-bound schedule for disposal of cases pending before any court. Constitutional Court may issue direction for the time-bound disposal of case only in exceptional circumstances. The issue of prioritizing the disposal of the cases should be best left to the decision of the concerned courts where the cases are pending.
Okay.
And in Guruvinder Singh Lordship, recently Supreme Court in paragraph 32, last 3 lines, although the case was relating to PMLA Act, but Lordship, observation is important. Therefore, mere delay in trials pertaining to grave offences as one involved in the instant case cannot be used as a ground to grant bail. Hence, the aforesaid argument on behalf of the appellant cannot be accepted.
Okay.
So these are the circumstances, Lordship. So in my humble submission, none of the petitioner are entitled to bail on the ground of long incarceration, delay in trial, and parity in the because some other accused has been granted bail. And Lordship, recently, although Recently on 5th of April, although the matter relating to 389 suspend of sentence in case of heinous crime, in paragraph.
Para?
I'm placing it. Paragraph 5. Lots. In the decision of Anwari Begum, bottles.
Yes. Yes.
In decision of the Anwari Begum versus Sir Muhammad and another, this court in paragraph 7 and 8 held as under. Even on cursory perusal of the High Court's order shows complete non-application of mind, though detailed examination of evidence and elaborate documentation of the merit of the case is to be avoided by the court while passing order on bail application. Yet a court dealing with bail application should be satisfied as to whether there is a prima facie case, but exhaustive exploration of the merit of the case is not necessary. The court dealing with the application for bail is required to exercise its discretion in judicious manner and not as a matter of course. There is need to indicate in the order the reasons for prima facie concluding why bail was being granted, particularly if an accused was charged of having committed a serious offense. It is necessary for the courts dealing with application for bail to consider among other circumstances the following factors to be granting bail. They are: 1, the nature of accusation and severity of the punishment in case of conviction and the nature of supporting evidence. 2, reasonable apprehension of tampering with the witnesses or apprehension of threat to the complainant. 3, prima facie satisfaction of the court in support of the charge. Any order devoid of such reasons suffers from non-application of mind, as was noted by the court in so and so, so and so, so and so. So this is my humble submission, Lordship. We are considering the object of the act and peculiar facts and circumstances of the case where narcotic drugs are involved. Lordship, they are not entitled to bail. Even then, some other accused has been granted bail. Lordship.
Okay, in item number 6, 7, and 8.
Lordship, only my argument will be same.
4 also.
4 also, Lordship. Because in all the cases, co-accusers.
Any counsel is there for 4, item number 4.
My management was there, but he's not. They are actually they file an application seeking bail on ground of on medical grounds. They've submitted some document also. Lordship, in that
Okay.
case, all facilities are available in Guwahati Medical College. If your
In
Lordship,
item number 4, what is the period of detention?
he was arrested. Probably in
Okay, first write for 6, 7, and 8.
22 probably. He was arrested subsequently. He filed anticipatory bail that was rejected because the allegation is that he was the owner of the truck from that contaminant was seized.
In item number
4.
6, 7, and 8, heard learned counsel for the petitioners. Also heard Mr. S.C. K.R., learned standing counsel NCB. Let this case be listed for delivery of orders on 16th of day after tomorrow. I will pass on.
My lord, may I just
You want to say something?
rebut to some of the submissions made by him? My lord? Only on the point of law, not on facts.
Okay.
My lord, primarily, my lord, 3 judgments were relied on. One is that Pappu Yadav case, my lord, which is 2005.
Yes.
2005 Pappu Yadav case. Then Pappu Yadav case was relied on to to bring home the point that prolonged incarceration.
Not prolonged. Prolonged word is not there. It says that
My lord,
if there is detention for
in a non-bailable
commission
case,
in a non-bailable
in a
case.
non-bailable case, if a person is detained,
then it
it
is not
cannot be said that it is violative of
violative
Article
of
21. Now, and my lord, it was also argued, if I have understood the submission correctly, that as a matter of rule, my lord, a person cannot be granted bail subject to satisfaction of Section 37 unless he completes 10 years.
Half of the punishment.
That is half. 10 years would be the half.
It depends on the offense.
And to buttress this point, Muhammad Muslim was relied on. Because Muhammad Muslim said 436 A would be applicable in NDPS case. In the same breath, my lord, the NCB argued that Joy Prakash is not the correct proposition of law.
What is Joy Prakash?
Sorry, Ravi Prakash.
Ravi Prakash,
Which says.
yes.
Now, my lord, if your lordship have this, both the judgment, Ravi Prakash and Muslim Mandal. Sorry, not Muslim, Muhammad Muslim. Your lordship will kindly see. Probably, my lord, while we read the judgment, we forgot who are the judges. It is the Justice Dipankar Datta was in Ravi Prakash and Justice Dipankar Datta was in Muhammad Muslim.
Okay.
So therefore, my lord, I am sure, my lord, a judge of a Supreme Court will not contradict himself at least. So, my lord, what I understand from Muhammad Muslim only says that 36A would be applicable in NDPS case. It does not say that in NDPS cases, you cannot grant bail unless somebody completes half of the maximum sentence. Maximum is 20 years, half of the, it does not know where it says. Rather, Muhammad Muslim para 2, it starts with that famous celebrated judgment of Husaira Khatun, which talks of Article 21 will have an override effect Husaina Khatun not yet, it is relied in Muhammad Muslim. Husaina Khatun is relied in Muhammad Muslim at paragraph 2. It starts with Husaina Khatun's first para is one-liner, special leave granted. Second para is Husaina Khatun. And then followed by another 1988 judgment that is also on Article 21, Hua delay in trial. This is one. So therefore, my lord, in my respectful submission, it would be wrong to argue that in an NDPS case, in view of the judgment rendered in Muhammad Muslim, a person cannot be granted bail if he does not complete half of the sentence. Rather, in Until's case, that Until, Satyendra Kumar Until case, I'll give the page number, my lord, and the para number exactly. In Until case, the Supreme Court says it is half of the minimum sentence. Then you can go ahead with bail. Half of the minimum sentence in Until.
Half of the minimum.
Minimum sentence in Until. Now, my lord, these are cases where, my lord, we need not probably have to lever much for bail. But those does not set a benchmark that 5 years, 6 years mandatory. These are, if you complete this, then we did not press on parity ground or this ground or that ground. We can go ahead only on the ground of prolonged incarceration. Now, my lord, the other judgment, surprisingly, which is relied in an NDPS case is this Pappu Yadav case. Now, my lord, I will indicate 3-4 paragraphs of Pappu Yadav case, that is 2005, 2 SCC, page 42. Now, my lord, before I go into Pappu Yadav's case, my lord will kindly appreciate the facts of Pappu Yadav case.
Yes.
My lord, in Pappu Yadav's case, the observation which the prosecution is relying is on the 9th bail application. 9th. Not 1, 2, 3, 4, 9. Out of this 9th bail application, 7 were rejected. In 4 bail application were rejected by the Honorable Supreme Court. And the time gap between the 8th bail application and the 9th bail application was 11 days. I can even say at para, my lord will say para 9, para 3, 5, 6, 7, 8. All these, my lord, talks of the different bail application file. 8 bail application were filed, 4 were rejected. 9th bail application within 11 days, all this observation came, my lord. Now, my lord, I was trying to find out whether Pappu Yadav lays down any rule as regard delay in trial vis-a-vis bail. My lord, Pappu Yadav, I'll have to read para 42 of Pappu Yadav. I'll read that, my lord. Para 42. I'm reading, my lord.
Yes.
Well, this clarifies the entire issue. My lord, Pappu Yadav is an authority. If your lordship takes up the SCC citation, then para 42, my lord. If it is live law and other citations, my lord, then probably the paragraphs will not tell you. In SCC, it is para 42.
Okay.
Now, my lord, Pappu Yadav is an authority on the parameters that has to be looked into in successive bail applications. Pappu Yadav is an authority on that point. In each and every paragraph in Pappu Yadav, Supreme Court was time and again reiterating that in successive bail application, without change of fact and change of law, the bail application normally should not be entertained. Pappu Yadav is an authority on successive bail application, not on bail application, which comes up for consideration for the first time. And paragraph 42 clarifies Pappu Yadav once and for all. Para 42, I'm reading only the first line. While deciding the cases on facts, more so in criminal cases, the court should bear in mind that each case must rest on its own facts, and the similarity of facts in one case cannot be used to bear in mind the conclusion of fact in another case.
Okay.
Meaning, my lord, if I understand this correctly, an indication is given by the apex court that it is not that whatever we have laid down in Pappu Yadav will be binding on other cases, because the court has reminded us that the precise line in criminal cases, the court should bear in mind that each case must rest on its own facts, and the similarity of facts in one case cannot be used to bear in mind the conclusion of facts in another case. Now, in this case, now, my lord, I am using Pappu Yadav I'm relying on Pappu Yadav for grant of bail in my case, my lord. Why, my lord? Because in my case, the facts are similar because the co-accused is enlarged on bail. So Pappu Yadav helps me. So to reject the bail of Sanjay Shah and other accused, which my sister is appearing, my lord, for those two accused, my lord, Pappu Yadav helps. Because for cancelling these two bail, we cannot rely on any other order passed in any other bail. That each case has to be decided on its facts. My lord, it is what Pappu Yadav says. Para 42. After discussing everything, this judgment is only 47 paragraphs. And after discussing all this, what had been read before this court by the prosecution, this is what the court has come to observe. Pappu Yadav. 9th bail application. And this is what the court has observed. Pappu Yadav, my lord, what should be the parameter in successive bail application? Now, my lord, Tarun Kumar. Tarun Kumar was also relied. I'll just touch on one paragraph of Tarun Kumar, because this parity cannot be a ground in Tarun Kumar. And Muhammad Muslim and this Ravi Prakash, my lord, same judge, Justice Dipankar Datta, who gave bail to Kejriwal. Now, my lord, Tarun Kumar, my lord, will kindly mark para 18 and 19. Because, my lord, Tarun Kumar is time and again pressed into service to show that parity cannot be a ground. Para 18. Para 18, only one line I'll rely for the sake of time, my lord. I'll rely just one line of para 18 and para 19 I'll rely. Whether your lordship has a copy
Yes,
of,
no, you read.
my lord, para 18, in between it reads, while applying the principle of parity, the court is required to focus. तरुण कुमार का judgment है ना ये? नहीं है. शासन assembly.
No,
Ah.
you read.
While applying the principle of parity, the court is required to focus upon the role attached to the accused whose application is under consideration. If the roles are different, my lord, this is a law long settled. If the roles are different, then parity cannot be pressed into service. But if the roles are identical, then parity has to be pressed into service. That is precisely what Tarun Kumar says. It is not my submission, I'm paraphrasing, quote unquote. While applying the principle of parity, the court is required to focus upon the role attached to the accused whose application is under consideration. This is one with regard to Tarun Kumar. Now, my lord, with regard to Tarun, para 19, my lord, we'll see. My lord, I'll read slowly para 19. Kindly, my lord, kindly bear with me. It is axiomatic that the principle of parity is based on the guarantee of positive equality before law enshrined in Article 14 of the Constitution. However, if any illegality or irregularity has been committed in favor of any individual or a group of individuals, or a wrong order has been passed by a judicial forum, others cannot invoke the jurisdiction of the higher court. Others cannot invoke the jurisdiction of the higher court or superior court for repeating or multiplying the same irregularity or illegality for passing similar wrong orders. Article 14 is not meant to perpetrate the illegality or irregularity. If there has been a benefit or advantage conferred on one or a set of people by any authority or by any court without legal basis, if any advantage is given without legal basis or justification, other person could not claim as a matter of right the benefit on the basis of such wrong decision. Meaning there, if I understand correctly, subject to what your lordship thinks, my lord, it's for Tarun Kumar to apply, it presupposes that the order is illegal and wrong. The order based on which somebody is seeking parity, that order, it presupposes that it is a wrong order.
If someone gets benefit on the
Okay.
basis of a wrong order,
So fast.
then parity may not be applicable.
So who will say whether this order is wrong or right?
It has to be illegal order.
It has to be sent by a superior court. Under Criminal Procedure 362, review power is not there. Therefore, the court was conscious to use the word superior or higher court. I cannot come in before a criminal court.
Read this line again.
I am reading it. That is what my lord Tarun Kumar says. However, if any illegality or irregularity has been committed in favor of any individual or a group of individuals, or a wrong order has been passed by a judicial forum, others cannot invoke the jurisdiction of the higher forum or superior court for repeating or multiplying the same irregularity or illegality or for passing similar wrong orders. Now, suppose an order is passed by the Sessions Court. High Court will not be bound by this order. If the High Court comes to a finding that the order passed by the Session Court is wrong, then the High Court is not bound. The High Court cannot extend the benefit of parity because Article 14 is a positive concept.
Yes.
So Tarun Kumar does not help a case where parity is sought before the same forum. By no,
Because that earlier order has to be a wrong order.
absolutely. Now, that is what Tarun Kumar presupposes, that order is wrong order. Now, who will say that order is wrong order? It has to be by a higher court or a superior court. That is why consciously the apex court have used the word higher or superior. That is, my lord, I was trying to find an opportunity to read this paragraph in some case. My lord, today I got it, and therefore I thought it was my bounden duty to indicate this para of Tarun Kumar. Because Tarun Kumar sweepingly is used for negating all pleas regarding. Now, my lord, the last judgment, my lord, which was relied, I'll just one paragraph of the judgment and I'll conclude, my lord. This is, yes, Ram Swarup judgment, that 1999, where the court said that in a murder case, 1% dies, in narcotic case, many percent dies. That sort of observation, my lord, was made in 1999. More than 20 years back, my lord. But still, my lord, I'll show that. Para 8 of that judgment. Huh? No. Para 8, last line. Yes. Para 8, the last line of this, if your lordship is having this. Yes.
Yes. Yes.
Oh. Now, my lord, the last line, your lordship will see para 8. Instead of attempting to take a holistic view of the harmful socio-economic consequences and health hazard which would accompany trafficking illegally in dangerous drugs, the court should implement the law in the spirit with which Parliament, after due deliberation, has amended. My lord, that social impact part, instead of going into the social impact and the hazards that may cause because of illegal trafficking, court should go into the true intent of the act. If I understand correctly, subject to correction, that court should not get swayed or carried away by all those social impacts. It says that instead of that, the court should implement the law in the spirit with which Parliament, after due deliberation, has amended. Now, my lord, what is the intent of the act? NDPS. Because those paragraphs were read, my lord, that one man died in murder and 100 men will be injured in drugs cases. The very judgment says that one should not get carried away by all these things. The court should implement the law as it is amended. Now, my lord, I'll indicate the law as enacted by the Parliament. Now, my lord, whenever we come up with an application for bail in a commercial quantity, immediately the first thing that, my lord, comes to our mind is section 37. Now, my lord, the justification of enacting section 37 is there in section 36 capital A of the NDPS Act. My lord, I was putting a question to myself, my lord. Why there is a need for constitution of special courts for dealing with NDPS cases? My lord, the special courts, these are manned by session judges. We don't have any special trained on NDPS, exclusively trained in NDPS cases who are manning the special courts, my lord. One or few trials, even I am participating, my lord. So these are invariably additional session judges or session judges, they are given that. Now, my lord, what was the need of then constituting a special trial, a special court? The purpose is expeditial disposal of cases. That you have an exclusive court to deal with NDPS cases, because there are stringent provisions like 37, no suspension, no remission, 32A. Because there are stringent provisions. Therefore, the Parliament said the intent is that we'll have special courts where we'll only deal with NDPS so that they are disposed, so that there are early disposal of cases. So, my lord, 37 cannot be read dehors of 36A. Otherwise, my lord, there was no need, because there is no special training, my lord, that somebody is trained in this act who will be a special judge in NDPS cases. Nothing. These are all are meant by, my lord, from our experience also we can submit in court. They are all, my lord, they are all session judges. Therefore, my lord, delay in trial, as your lordship correctly pointed out, 1 year, 6 months to whatever, I do not know, my lord, every day there is a development in the law, my lord. But then till now, even I could lay my hand on 1 year, 6 months, not prior to, I have not found it. My lord, in a recent case of our High Court where I was the counsel, I was appearing for 3 persons. 2 persons got bail, 1 person's bail was rejected. My sister is also there for one of the accused.
Yes, that was very good.
Yes.
Last occasion I made this sufficient.
There was, for 3 person, I moved a bail application. For 1 person, my sister moved the bail application. Now, our High Court granted bail to 2 persons in my bail application and rejected the bail of 1 person in my bail application and rejected the bail of my sister's client.
There are
Direction for direction for expedition, but bail was not granted. That's the bottom line. We challenged it in the Supreme Court. Supreme Court granted bail to that also.
Okay.
Lalanu Sheikh. I can tell the name also, Lalanu Sheikh. There are another 2 judgments, another 2 cases which are also pending before the Supreme Court. The orders.
within 6 months.
Because my sister is reminding me, my lord, because in that case there were three times directions were given for expeditious disposal.
Within 6 months.
Within 6 months, within 6 months, my lord, those expeditious. I don't blame the NCP as such, my lord. The problem with the NCP is that, my lord, because their officers are posted in different parts of the country, my lord. So because of their official commitments, they cannot come. But at the end of the day, my lord, not at the cost of the people who are lying. They also have their family. There are judgments, my lord, I can rely on 2024 judgment of our trial court where both of us has appeared in many cases where acquittals are granted after 5 years, 6 years. Who will compensate 5 years of his life, my lord? Their children's, my lord, I am not a witness to the case. I am not saying if somebody has committed a wrong, they have to be scot-free. But my lord, the courts there are many instances where people are acquitted after 5 years or 6 years. So that's my humble submission, my lord. This law, that the last judgment which the NCB has led 1999 also says that it is not the emotions, the social intent, it is the law that has to be implemented in its correct address. And 2005, I agree. That's my humble submission.
Date it did not be. It was day after tomorrow,
I am deeply
not day after tomorrow, one more day
I am deeply obliged.
because of your submissions.
I am deeply obliged.
On Friday, I will deliver this.
Absolutely. Absolutely.
You
My-
give that judgment.
My lord, in item number 6, I'm appealing in item number 6 and 8. In 6, Surinder Kumar, he is suffering from illness. My learned friend has stated that.
You have made your
No,
submission.
lordship, I want to make some more submission, lordship, because lordship granted bail in appeal. It is not relevant, lordship, in this case, but lordship granted bail in appeal in NDPS case, who was inside jail more than 5 years because of medical ground, lordship. But lordship granted bail on 22/3/2024, but that only on the medical ground, but the unfortunately, the person expired on last Saturday also. So he is stated that he is in the, there is GMC is there and we can provide the treatment to the person. If lordship, such things will happen, what will be their lordship, that this is the order of this honorable court. In appeal, lordship granted bail, though objection was there from the side of PP lordship. Even after that, lordship considered all the medical report, lordship. I'm very grateful to your lordship, so that the person visit his house, lordship.
Now, in this case, what is your submission?
My submission is that, lordship, though he has stated we can provide the treatment at GMCH, lordship, all the person got bail in this case in a similar footing, what my learned friend.
Okay. That
make-
submission you have already made.
Yes,
He
lordship.
has also countered it. You
So,
were to
my-
give one judgment.
Yes.
Which judgment?
That is, lordship, just now, my learned friend has stated that regarding that once rejected by the honorable court and then approached.
Provide a
Supreme-
copy of that.
Yes,
judgment.
yes, of course, lordship. And Lordship, I made my submission regarding section 36(1), Lordship, speedy trial. And item number 8, the person only his name submitted in the final annex annex with the final complaint, Lordship, only on the basis of the statement recorded under 67. And that too, even Lordship, his name is not clearly mentioned in the statement in 67, recorded under 67, Lordship. And in that case also, the main accused from whose position contraband were recovered, he got bail from the son of Goiti. In item number 8.
Staple money. Actually. Okay,
Lordship, may I place this one also, the bail in appeal, Lordship?
you may place it. I may not prohibit anyone
No,
from
no, no,
placing the
I'm
judge.
not objecting. Let them, whatever they want, they submit.
Whatever
day-
they want, no.
Day after tomorrow, on Friday I will.
I have one submission with regard to medical ground. Lordship is to see from which element he is suffering. That is to be taken into consideration.
Ailment, the
Or-
medical report is there, my lord, regarding the ailment, Lordship.
Lordship
And he is as at about 67 years old person, Lordship. And other young person released on bail, Lordship. Because of their fault, Lordship, because in so many dates, the witnesses are not appeared before the court.
Okay. Argument is over for this side.
Lordship-
You have anything to submit?
Yes, Lordship, with
What?
regard to medical, Lordship is to see the
Ailment.
medical documents are there and all facilities are available here. That cannot be ground for releasing a person immediately. Since other accused has been granted bail and subsequently died.
If he will die inside the jail, Lordship, who will compensate for that? He is as at about 67 years old, my lord.
Friday. On Friday.
Obliged, Lord.
Is there any lawyer for item number 4?
Abdullah was there, probably is not there today. Abdullah.
You can fix it for, you have made your submission, same submission
Lordship,
on Friday,
not,
along with this.
I'll inform you.
Item number 4 also. Lawyers separately बताओ. Sarika.
This matter may be adjourned for the day, my lord. I guess council Ahmed Chaudhary is out of session.
Okay. Third, Mr.
Yeah, Ahmed.
A. Ahmed, learned counsel for the petitioner who prays for an adjournment on the ground that conducting counsel Mr. M. A. Chaudhary is out of station. Learned additional public prosecutor does not oppose the prayer. Hence the prayer is allowed. Let this matter be listed after a week.
After a week now. My
My lord, in this case, actually it should be listed on motion, but it is listed as bail hearing. If FIR is page 17, my lord.
Why it has come to this court?
My lord,
Why it has come to this court?
it is listed.
No, because I am not taking bail roster
Yes.
unless
yes, yes.
the case is.
It's wrongly
dealt with-
listed on the
Wrongly, maybe-
bail
maybe.
hearing laws. It should be in motion.
It should be
For the
listed
first
on
time.
motion.
Whether I have dealt with this matter earlier.
I have not done that.
Whether co-accused, then
Yes,
why
Many persons are released on bail, they arrested.
in this
And-
case?
Yes. in this
Who-
case. And I submitted my lord, their forwarding report also. page 18.
No, no, my first query is why this case is listed before, because
I am no other.
then it has to go to regular bail court.
Well, no problem. No problem.
It appears, heard Mr.
Actually,
Jay-
my lord, in this case also, my name is not, I am not signed a Gulatama, but my name has been reflected. My senior, junior counsel, he is an Sheikh, my lord, he is a operator. He
Pardon?
requested me to make something.
Whose name is there in Wakalatnama?
At P. Ahmed,
Heard Mr. J. Ahmed submitting on behalf of Mr.
P. Ahmed.
Ahmed. Also heard Mr. K. Bosho, learned additional public prosecutor. It appears that this case has been wrongly listed before this court under hearing column. It should be, registry is directed to list this case before appropriate court under motion column.
235.
When do you want it?
Next,
In the- Within a week,
next week, my lord.
after a week.
May I please, Lordship. So this is Lordship, matter relates to Zimmer Lordship, Zimmer of some rice Lordship. Here Lordship in the earlier report, Lordship was heard this matter Lordship. And Lordship may have the order dated 23/2024. There is an observation in there Lordship. And that's the CD was called for Lordship, and my learned friend was directed to take a report that whether the rice is already sold or not.
Yes, what
Yes,
is,
Yes, there is.
Lordship, here the CD is received. And
CD was called for.
CD was called for and that is received. And as per the CD, Lordship, they have, to some extent, they have completed their investigation. And that the additional, your investigation is left, but they have prepared one search sheet. And Lordship, the other part regarding that is that whether that that was sold or not, that is not available. That report is not here along with the city. Otherwise, the note is here. One note states that, Lordship, it is this dated your this 13/10/2023. As per that note, Lordship, that is the relevant part.
what it says? Okay.
It states that as because one criminal revision petition was filed before the additional session judge Kamrup, and there was a stay. So he submitted a
any
report
stay?
there.
No mistake.
That time, Lordship. Later part maybe, but maybe that was pending that time. Here, Lordship, in this petition, there are 3 numbers of order. 2 passed by the CGM and another one by the session judge. It is in the revision petition. In the revision petition, they assailed the order passed by the learned CGM regarding that was the pass that there could be auction of that particular the seized your rice bits, 49 kg of each. Now, in that particular order, they were unable to produce the receipt regarding by any documents.
Now, how the court will find out that you are the owner of the rights?
Yes, Lordship. That is
On what
the
basis?
question.
Yes, Lordship, basis is the Lordship. To some extent, Lordship, I have given some report of the villagers, Lordship. Those who Lordship, a similar person, Lordship, there are other some person also, Lordship, they stated that they stated before the police, Lordship, that we sold it in the open market. Lordship, they already may have this space, Lordship. 21 is translated copy, Lordship, and 22 is the relevant vernacular, Lordship. So, Lordship, this is on Eastern, Lordship. Because the villagers, Lordship, they sold it in the open market, Lordship. There's the Saturday market, Lordship, weekly market, and this is also, Lordship, as on today, Lordship, they are happening, Lordship. So, Lordship, they are given this writing to the before the officer, before the IO, Lordship. or official in charge, lordship. So lordship, other than this, lordship, nobody is claiming that this may be.
No, but no, if nobody is claiming, that
Claiming-
does not
Yes,
mean that you
Yes,
will claim.
lordship.
Yes, I am claiming, lordship.
nobody is
Merely
another
because
part is that
nobody is claiming.
it is recover, it is seized from my position, lordship. This is lordship, Caesar stage, lordship. From my position, from my godown, lordship. That also, lordship, may,
From your go down.
yes, lordship, my godown, lordship. This is the FIR also says, lordship, and for the Caesar list also it is reflected, lordship. Caesar list may currently have a page 19, lordship. This is a Caesar list, lordship. Here says from my godown, lordship. Lordship, what that lordship, translator to the given this translator to be maybe type to be taken, lordship.
Now, what is the materials in the case diary, whether it was found to be stolen?
Yes, lordship. That was says and lordship, that is the page 22, that is the annexure 5. Whether under the Indian Evidence Act, since this document has any evidentiary value, that I am the owner.
No, but it was recovered from his possession.
His possession, and that is rightly it is stated in the judgment, in the criminal revision. It is in the, I have flag marked that portion in the LCR also.
What it says?
Lordship, it is lordship, it is in the page number 50, lords. Page number 50 of the petition.
What is the reason for rejecting?
Yes, lordship. May I read it out?
Yes, yes.
Yes, lordship, the para 11. Again, the learned additional PP on behalf of the respondents had submitted that in the report call from the IO of this case, the IO reported that the petitioner is not legal owner of the says rice bags, and the petitioner could not produce any valid document in respect of says rice. The learned additional PP also submitted that the submission or argument of the petitioner side that some of sellers, villagers gave a writing to the IC of such and such police outpost on 15/5/2023, stating that they used to sell the said atop rice at the open market of Josimuli to the petitioner as they do not eat consume the said rice. Lordship, kindly be noted, they do not eat and consume the rice, and they also clarified that the petitioner has not purchased the said rice from any non-gov institution. Is not believable considering the huge quantity of said rice, 460 numbers of bags containing rice, approximately 49 kg rice in each bag. The learned additional PP also submitted that as the case is still in the stage of investigation, hence the submission of argument of the petitioner side that the Office of the Food Corporation of India, Divisional Office Guwahati also certified that as per records, there is no incident of if there is theft or missing of rice stock as reported in the depots under FCI DO Guwahati during the questionable period, and such the offense under section 379(4)(11) IPC does not attract all against the present petitioner is not acceptable and premature. Now, lordship, in paragraph number 12, considering the submission both the sides, the light of the materials on record, I find the following. A, admittedly, the petitioner is the accused of such and such in connection with which the rice was seized, who has failed to produce any valid document to prove that he is the legal owner of or 60 numbers of bags containing
Okay,
rice.
till now, why it was not auctioned?
Lordship, in this regard, we need the report. That
That
report
report
is
is
not available.
Now you
on-
take it telephonically,
Yes, Lord.
just a line whether rice has been auctioned. or it
Auction
is-
or
it
not,
is-
auction or not. still.
That information you take today itself,
Mm,
try to take, because 1 hour is remain.
Yes, lordship, we can
Because
make a
if-
telephonic call, lordship.
There is no stay granted on this auction sale order. This-
Auction sale order, Lordship, there are some orders before that is in the LCR, because it is the final. It is the final order.
Okay,
It is the final order.
but final order
final order is the dated lordship, it is the judgment is delivered on lordship. The judgment dated lordship, 9/11/2023. 9/11/2023,
So,
and this is from the CD, what I have stated, it is on 13/10/2023.
so 6 months have lapsed.
Yes, from 9/11, from
And
9/11.
rice is a perishable item.
Yes, yes, lordship. Yes,
So you find out whether it
Yes,
has been
yes, yes.
sold or not.
yes,
And from whom it has been stolen,
yes,
from whom it, whether CD, case diary indicate, you have submitted that the case is ready for laying charge sheet.
yes, lordship, it is,
Then from whom it has been stolen.
They have also taken the clearance from the FCA lordship. They should say that no, there is no anything that we lost from our possession or anywhere lordship. So lordship, if anybody not claim, it's not claiming there, government is saying that there is nothing to claim us and this is not our rights. Then lordship, then how they can keep it lordship? They cannot.
name is not mentioned, lordship.
Then what is the, from,
Name is not mentioned, lordship. And so they have not,
He already get almost, by tomorrow it will be full complete 1 year. So lordship, by the time.
from case diary, whether it is revealed that from whom it is stolen.
no, so lordship, it is not, they opened it up. They have not completed. But as per the report, because it is sent on 3/4/2024.
3/4.
3/4,
So up to April,
yes.
whether the rice is stolen rice, any indication?
Lordship, in the, here they have stated like this.
Otherwise, then you tell me within an hour whether the auction has been made or not.
Yes, yes,
What is the,
yes,
you give me the case diary, I'll pass orders
yes.
after.
That's why this honorable court passed this order on 20 March lordship.
When will you tell me?
Lordship, I will try immediately.
Okay,
In this court, I
Then
will try to
after-
find it out.
after getting information from, I'm reserving the order.
Lordship.
After getting information from him, I'll pass the orders. Heard. Mr. S. Hawk, learned counsel for the petitioner. Also heard Mr. K. Basha, learned additional public prosecutor. The hearing is complete. However, learned additional public prosecutor is requested to let this court know as to whether the auction sale has, as directed by the learned chief judicial magistrate, where auction sale order is of which court?
Of the CJM Kamrup lordship.
Chief judicial magistrate Kamrup Metro or
No, Kamrup lordship.
Kamrup has been complied with or not. The judgment is reserved.
Ola.
Onto আসলে, no? Yes, Mr.
FPJ lawsuit, matter relates to cancellation of the bail granted by a lawsuit by suppressing the facts, my lord. My lord, they have filed an objection, my lord. In this objection, they have raised one point that Wakalatnama was not signed by the actual person, but it is a false, my lord. We can produce the person if required, my lord, that he has signed the Wakalatnama. Now, that is the either thing, my lord. Whether Wakalatnama signed or not, that is a different issue. issue, main core issue before your lordship to find out whether prior to your application filed by them, before your lordship, they filed another application before the learned Honorable Justice Shoikia. And the Honorable Justice Shoikia has rejected that bail petition. And they have not mentioned this thing while they have filed the application, madam, which is that is a gross mistake, illegality done by the petitioner. I don't say which lawyer may not know it, my lord, but it is the gross illegality done by the petitioners, those who in know of the fact, but they have not asked the advocate that yes, earlier it was rejected. So that is on that point, core point alone, they are not entitled to get the bail anymore, my lord. And my lord, in this case, Supreme Court judgment, it is para 24, my lord, there is a judgment, very latest judgment. Kindly peruse the para 24, my lord.
Which,
20, my lord, I am giving, my lord. In this case, Supreme Court has given a guideline that in case of rejected bail petition, what should be the procedure to be maintained by the registry or the person concerned or the petitioner.
there is notification from our High Court also.
A High Court notification also has come.
In pursuant to this
Yes,
judgment,
yes.
High Court,
This is prior to this notification judgment.
Even then, guideline would follow. Even the filer.
This is prior to this judgment.
no, but the question is whether you have given an affidavit wherein you have suppressed the fact. If there is a suppression of facts, that
We have filed our objection, my lord, in this petition, my lord.
Objection has got no-
We have explained everything, my lord.
Yes, we have read, my lord, we have, only that they raised that the Okalana was not found by the
This
genuine
is
person. That
preliminary
is a
issue, my
fault.
lord, whether petition is maintainable by third party. That is another, my lord. On merit also, my lord. Bail petition was
where is your objection?
objection filed on, my lord, 30th of April, my lord.
It is not third party, my lord.
Third.
Informant. So reformer is the informant, my lord. Informant has got every right to file.
Inform, my lord, this is manipulation, my lord.
Manipulation, how? Signature.
No, let me,
Yeah, I will bring him before the court. You put in your signature, get it sent, examination.
We have filed on 30th of April, my lord.
Putul. এতে সব ফ্ল্যাগ করে থই দিছে objection কর
IA 139.
Bharat file to Tangyal.
Tag 1.
Find out the
My lord,
objection.
in that objection also, you are having the copy. They have.
No, where is the objection?
It may not be tagged, my lord, by the registry.
ইমানদের কেন কেন হবে? শেখ হইছে?
Tag 1, check হয়েছে। Check হয়েছে? এটা না, এটাই petition আছে। এটা তো আইয়ে।
Main file.
নাই? ও, এটাই তো আইয়ে। Single আইয়ে।
You can look at this also, this file also. You can submit.
সাইজা নিবি। দিতে হলে
Let the objection come.
এটা তো অরিজিনাল বিএটি। ইয়াতে না,
এটা থাকিব পারে।
নাই এটাই petition আছে। Main BEd. Complete.
File in the month of April, ne?
হ্যাঁ, 30 তারিখ।
As per the office note, dated 25/4/2024.
25/4, my lord.
It
We
is-
have filed on 34 after 5 days of notice.
After that, there is no. Then that objection has to be placed on the.
Lordship.
In that event, I leave it to Lordship if you.
Unless the objection is put on, is placed
If-
on record, how I will take cognizance of that.
Yes,
Heard Mr. S. C. Vishwas, Namit counsel for the petitioner.
filing slip আছে না?
Also heard Mr.
Filing slip.
Ali.
Huh?
Lanet. Counsel for respondent,
1 to 9, my lord.
respondent number 1 to 9, as well as Mr. A. Bashir, Lanet, additional public prosecutor. Though Mr. R. Ali, Lanet, counsel for the respondent has submitted that the respondent number 1 to 9 have filed written objection on 34/2024. However, on perusal of the office note, it appears that till 20 office note dated 25/4/2024, it appears that no written objection has been received by the registry as on 25/4/2024. As the written objection is stated to be filed only on 30/4/2024. The registry is directed to put up the said objection along with this case record
ডিফেক্টিভ করে আছে।
with a proper office note.
rectify করে দিও।
আমি তো রাখি
After a week,
মানে ডেট মে বি ফিক্সড
a fixed date. On 27/5/2000.
My lord, I am Ismar Prayan, my lord. Item number 4, my lord. Youngest counsel, my lord, S.A. Siddhar is out of station, my lord. He just had informed me, my lord. The matter had already gone, my lord. That may be taken up next Friday or.
No, it is fixed for delivery of orders on
Next Friday, my lord,
17.
17, my lord.
And that day, if you want to say something.
My lord.